Domestic violence can affect a Florida divorce pretty dramatically. You see, the judges will apply a standard in the beginning of the case, a presumption of 50-50 time sharing, for example, if there's children. But there are several factors that the judge has to take into consideration when determining unequal time sharing, and domestic violence is at the top of that list. In fact, you don't even need to be arrested for domestic violence for it to affect your divorce case. If there's an allegation that one party committed domestic violence against the other, especially if it was in the presence of any minor children, that can dramatically affect the outcome of what time sharing is going to look like on a permanent basis moving forward. A protection order in Florida is also called an injunction. And so an injunction is basically a restraining order, and it would be filed in a circumstance of domestic violence, stalking, or an aggravated assault of some sort from one party against the other. And so the victim of that domestic violence can actually petition the court for an injunction, which would create a no contact order between the parties. This is a separate issue from a divorce and even gets assigned a separate case number. But when that happens, when an injunction's been entered, the divorce court will take notice, and it may very well affect what happens in the divorce proceedings. A prenuptial agreement, or a prenup, is basically an agreement between two spouses before they're spouses to protect one of their assets from the other. Now, sometimes it's not even for nefarious reasons. The prenup can be used to actually protect those assets from extended family and other people that tend to come out of the woodwork when two parties get married and the wealth is very unequally distributed. The whole goal of this is to keep separate assets separate from marital assets that are accumulated in the course of the marriage. When it comes to tax implications in a divorce, these things can actually be very serious. And the fact of the matter is, the attorneys and the judges aren't tax experts. So when there are serious tax implications, for example, if the innocent spouse rule is brought up, like for a scenario where one spouse incurred a huge tax debt that the other spouse had no idea about, it's really important to bring in some tax experts and accountants to advise on that in the divorce case to make sure everyone is protected. We often hear the term common law marriage, this notion that, well, if we've been together for 10 years or more, we're automatically married. But Florida specifically does not have common law marriage. So that means that person that you've been living with for the last 20 years, if something were to happen, you actually don't have a legal basis to their assets. There's no such thing as common law marriage in Florida.